hear argument next in Syntel-Sterling v. TriZetto Group, 211370.
Thank you.
Counsel, good morning.
Good morning, Judge Loyer, Canon Shamigam of Paul Weiss for the Syntel appellants. May it please the court. The district court in this case committed fundamental errors as to both liability and damages in upholding the award of nearly $600 million for violations of the Federal Defend Trade Secrets Act. As to liability, the district court permitted TriZetto to skirt the requirement that it identify its claimed trade secrets with particularity. That requirement is necessary to define the protected property, to permit a defendant to be able to defend itself, and to ensure that a lay jury can determine the existence of a trade secret. Here, however, TriZetto made no effort even to identify the majority of the claimed trade secrets at trial, merely providing the jury with a list of documents.
Why isn't that enough to satisfy the particularity or specificity requirement?
It isn't enough because when you look at the cases that have applied this requirement, they have consistently done something more. They have required the plaintiff to identify with detail the protected subject matter. Now, that doesn't require a line-by-line analysis, but it requires something more than merely saying, here is a list of documents or even a single document, here is some source code.
How does Mr. Noonan's testimony come up short then? As to software trade secrets, tools trade secrets, or the manuals and guides?
So I think it's clearest with regard to the guides and manuals because Mr. Noonan only talked about one of those 97 guides and manuals in any detail. In fact, the list hadn't even been provided to the jury at that point. And all that he did, and this is at pages 246 to 250 of the appendix, was to describe the relevant guide, the data model guide, as, quote, describing in a technical way the architecture of TriZetto's database. Now, that's a description, and to be sure, there were descriptions of, for instance, what the software did.
There were also exhibits.
Well, there were in the sense that the documents were available to the jury. But TriZetto's entire argument was essentially to say to the jury, just go and look at this material and figure out for yourself what is protected.
I mean,
and
it might not be the best argument, but in reviewing a jury verdict now, don't we have to assume it did just that? And then the question becomes whether it was sufficient to admit the ruling?
Well, I don't think so, Judge Radji, because if the court were to do that, it would eliminate the specificity requirement as a practical matter entirely.
You did ask for a specificity charge. I did see that, right?
Yes, that is correct.
The district court did not give.
With regard to the DTSA claim, that is correct.
Right. Now, you did not argue on appeal that the error was with respect to the charge. You bring a straightforward sufficiency challenge, correct? That
right. And that,
whether the charge was given or not, this evidence is not sufficient. Is
yes, well, and it's complicated,
understand?
Judge Radji, by the fact that the instruction was given with regard to the New York state law trade secret claim. But let's put that aside. I'm willing to acknowledge that, which is to say,
if that's the case, why don't we assume that the jury not only heard the testimony, but looked at the exhibits, and together they're enough to satisfy specificity?
I don't think so, because that would be conflating the argument that we're making concerning the specificity requirement with the substantive requirement for what qualifies as a trade secret. And I think that those two things...
Explain that to me. So.
Well, I will. It's a little bit metaphysical, and I have to say that the cases that address this issue are a little bit under-theorized. Everyone acknowledges that there is a specificity requirement. But I think the right way to think about it, Judge Radji, is that the specificity requirement defines the trade secret that is protected. In other words, it tells you what the property interest is. And this is somewhat unique to the context of trade secrets, because if you think about other types of intellectual property, like patents and copyrights, those are, of course, defined typically by...
Is it sufficiently defined by reference to a testimony, in this case, Mr. Noonan, specifically saying that it's kept in a confidential way, it's regarded as confidential information?
No, I don't think that it is, because it's one thing to say that the document is kept confidential. The really critical question is, what is the know-how? What is the subject matter that is protected? And I would point the court...
Isn't it enough just to say how it works in the general manner? I mean, that for example, the case study allows them to dry run alterations with regard to the programming for a particular client, maybe a health insurer as opposed to a hospital, and that they're then able to anticipate difficulties with regard to the software without actually going through working out bugs after it's been inserted. That's a particular kind of aspect of this program that makes it unique to TriZetto's experience.
So I think that something more would be required than even that, but I underscore at the outset, Judge Wesley...
How much more would you ask then?
So I think at a minimum, there has to be a description of what it is in the document, in the source code, that is trade secret. And I would point the court to...
You do Google searches, don't you?
From time to time, yes.
And how Google does its search is incredibly important information to people who want to utilize a Google search, right?
Correct.
And Google probably has something within its algorithm that is unique and a trade secret. Does Google have to disclose the exact what makes it unique, or does it just have to show generally that there's aspects of Google's algorithm that then order who comes up 1 through 3 on the Google search?
It does have to describe it, and I would point the court to the Third Circuit's decision in Oakwood Labs.
Describe it how, sir?
Well,
How
I
it
think this
works,
language...
how it works, or the particulars of what makes it work?
It's a little bit of both. Here's what the Third Circuit said, which I think is a definition above which I can do no better. It said, quote, to satisfy the particularity requirement, quote, the subject matter of the trade secret must be described with sufficient particularity to separate it from matters of general knowledge in the trade or of special knowledge of those persons who are skilled in the trade, and to permit the defendant to ascertain at least the boundaries within which the secret lies.
Okay.
And I would note that with regard to the vast majority of the trade secrets here, we don't even have what you just suggested in our colloquy, Judge Wesley, with regard to one of the tools. And so the straightest path on this issue, I would submit, is that if you agree that with regard to the 96 of the 97 guides and manuals that were just included in a subsequently provided list, with no testimony at all, that is insufficient. I would point the court to the Third Circuit's decision in Givethon. Then at a minimum, the court needs to vacate and remand for a new trial. Now, I do want to spend a couple of minutes on the damages issue because I know the time is short.
Why just back up. Why isn't one way to look at this is whether the defendant was able to counter these claims?
Well, if
you look at this record, there's no sense, at least in my reading, that the defendant was not, that your client was not able to counter the claims. So there's every indication that it understood what the trade secrets were that were at issue at trial.
Well, I disagree respectfully with that, Judge Lohier, and let me explain why I think this is so important. TriZetto's whole strategy here was, in some sense, to swamp the jury by claiming 104 trade secrets and not walking through all of them. That placed the burden of...
Two are not disputed.
With regard to appropriation, that is correct because of the district court's preclusion order. But of course, here we're talking about the threshold requirement of defining the trade secret. Mm-hmm. And I do think that if you read the record fairly as a whole, it was very difficult to defend against this precisely because there was a failure to identify the trade secrets such that we could really drill down on not just the question of what met the substantive requirements for a trade secret, but also what was misappropriated here. And so I think in some sense that's why this requirement is so important and why courts have consistently said that the requirement is important. And to the extent that there might be difficult questions with how to draw the line in certain cases, I think we would acknowledge that the line is somewhere between doing nothing and going line by line in a way that would require you effectively to expose the trade secret in court. We're not saying that Coca-Cola has to come in and read the recipe.
I'm going to give you a minute. You were going to turn to damages, and I interrupted you.
Well, I do, because I think that issue is extraordinarily important in its own right. And our fundamental submission is that the award of $285 million in avoided costs here was wildly disproportionate. At a minimum, that award constitutes an obvious windfall to TriZetto, because the undisputed evidence here indicated that TriZetto suffered no more than $8.5 million in lost profits as a result of the alleged misappropriation. And in fact, the profits to us, it is once again incontroverted, were even smaller.
The thing that I'm interested in is your client also is enjoined from employing any of the trade secrets that you allegedly employed in competing with them. Is that correct?
Yes, that is correct. There is a permanent injunction in place, which again underscores...
Doesn't that then seem like a double recovery for TriZetto? Because, as I understand it, the $285 million is a projection or a determination of what their development costs were in developing these trade secrets. And it seems to me that if they're made whole by that, then somehow it's almost as if you purchased it, so that the playing field's then level. Why wouldn't the two of you compete with the same amount of development costs?
That is exactly correct, Judge Wesley. And let me set out our view of when avoided costs are appropriate and then bring in the relevance of the injunction. So our submission is that under sort of basic principles of compensatory damages, avoided costs are really appropriate in only limited circumstances. First, where you destroy the value of the trade secret. Say you had a situation where you released Coca-Cola's formula to the New York Times. That's a pretty straightforward example. But leaving that aside, I think in a case where what you're trying to do, as TriZetto is to use avoided costs as a proxy of the unjust benefit to us. We think that avoided costs are unavailable where the defendant's gain can be readily calculated, which is true here, or where the defendant's benefit does not equal the full cost of developing the trade secrets, and that's where the injunction comes into play here. Because at most, Syntel, it is alleged, used the trade secrets, the claimed trade secrets, only in providing services to a single additional customer, UHG. That is the $8.5 million figure. Now, as you say, I suppose that one could imagine a hypothetical world in which, if we were not enjoined, we would use the trade secrets not only to provide services.
Well beyond United Health, that's the idea.
Yes, right, and to develop competing software, which was never our goal, parenthetically. But when you look at the relatively few cases where avoided costs are awarded, they're typically cases in which the defendant is fully exploiting the trade secrets. But the permanent injunction prevents us from doing that. And one of the most notable things about TriZetto's brief is that at one point, TriZetto says, well, look, if you think this is a problem, get rid of the permanent injunction. And that illustrates well what is going on here. TriZetto wants this windfall. And make no doubt about it, TriZetto makes quite clear that what it is trying to do here is to use this award to punish us. On page 70 of their brief, they say that this is necessary so that Syntel can face meaningful consequences. But that's not a compensatory award under any sense.
I think we have your argument.
Yes, that renders it punitive. And of course, there was a punitive damages award in this case as well. Thank you, Judge Laurier.
Thank you. We'll hear from Mr. O'Quinn for TriZetto. Good morning.
Good morning. Thank you, Judge Lohier. May it please the court, John O'Quinn on behalf of TriZetto. As the district court found following the jury trial, the evidence showed that Syntel engaged in a sustained course of illegal conduct against TriZetto pursuant to a long-term strategy to pursue a $1 billion market opportunity in which it expected to make over $100 million a year. In this case, this is an unusual trade secrets case. There's no question or dispute over what was taken. There's no question over what was misappropriated. There's no question that they had notice of the things that were asserted to be trade secrets individually, using the gold standard for identification recognized by courts throughout the country, that if you're talking about software, you can identify it using a source code, and following the line that's been drawn between things that were not adequately identified and that were adequately identified by any number of district courts within this circuit, namely, did you give the jury a specific exhibit to be able to access? Because that is exactly what...
So that's what you're saying satisfies the sufficiency requirement, not the testimony of the witness by himself, but rather the testimony considered in conjunction with the exhibit, identifying these source codes.
I think that's exactly
Your
right.
adversary says that sent the jury on a hunt for needles in haystacks, at least that's how I understood it. So why don't you tell us why we shouldn't be concerned about that on sufficiency?
Sure. So I think there are sort of three issues that are packed into there. One is this idea of identification. And my friend on the other side takes the idea of identification and then tries to load up a lot of other things with it. There's no question here what was identified as trade secrets. There were 104 specific exhibits that were shown to the jury either individually or as a list and then discussed by various witnesses. The second issue is, was there sufficient evidence for the jury to be able to decide were these things kept confidential? Are they valuable because they were kept confidential? And that is what the testimony of the witnesses, Mr. Noonan, Mr. Bergeron, were both addressed to. And, you know, with respect to the manuals, and this gets to the third point that I want to make, this court can affirm even if you don't think a single manual was adequately identified. And just to be clear, I mean, again,
Why do you say that?
but because this is a verdict that goes on which there was a single legal theory that is a violation of the DTSA, on which there were different factual theories. And if one of them was insufficient factually, that's not enough to vacate the entirety of the verdict. That's the Supreme Court's decision. Justice Scalia wrote it in the Griffin
So you're
case.
saying there's one unit violation based, and that can rest on one violation of the trade secret, trade secret violation.
So for purposes of liability under the DTSA, the judgment of liability can be affirmed if any single one trade secret was properly found to be misappropriated, if there's sufficient evidence even as to one. And that's why they don't even try. They don't, because they know that they can't show this court that
Have we so held?
Your Honor, I mean, if you look, for example, at the Salmonese case that's cited in our brief, as well as the Supreme Court's decision in Griffin, if you have, the argument here is ultimately about sufficiency of the
You're resting
evidence.
your argument based on the DTSA, so if we held in that context.
I don't think this court has had a DTSA case where it has looked at it this way.
I don't mean to interrupt you, but you're saying it wasn't tried in a way that
Right.
the defense was, well, we may have, if you found one, that only caused so much injury. If you found two, that might have caused more injury. You're saying it was tried that if any one trade secret was found, the damages, the ultimate injury to your client was the same.
Judge Wesley, almost. So I'm making 2 points. First, with respect to liability, if you look at Appendix 524, that's where the jury was instructed that it's a single DTSA claim, any one factual theory will do. Then, with respect to the issue of damages, Judge Wesley, if you look at Appendix 421 to 425, that's the testimony of Mr. Britvin, and under his testimony, there were essentially there were more than that, but for present purposes, there were two damages theories that were put to the jury. One was, if you just find the manuals to have been misappropriated, what are the damages? The damages there would have been $189 million. For any of the other trade secrets, so the tools, the data dictionary, and to the extent there's any doubt that it was identified, and they adequately, they copied the data dictionary source code verbatim. We identified the data dictionary source code as being the trade secret. There was no doubt that it was kept confidential, and there was no doubt that the data dictionary itself was testified to have been the product of time and energy on how to organize the data. That's Appendix 261. But coming back, if they misappropriated the data dictionary, the custom code impact tool, the test cases, the DB build, any single one of those.
In the exhibit at 21.
Yeah, any single one other than the manuals, the damages were 284 or 285 million, which is what the jury awarded.
That's what they gave you.
And that's what they gave. So you would presume that the jury had, acted consistent with substantial evidence, unless the other side showed that it did not. And so the basis for the jury's award tells you, no question about it, that they had to find something in addition to the manuals having been misappropriated. Now, I think there was more than adequate testimony about the manuals. I mean, again, their challenge on appeal is identification. Identification was very clear. The jury the jury could, quote, ascertain the boundaries within which the secret lies, end quote. That's the Oakwood case. And by identifying the manuals, there's no question that the jury could do that. Then you had testimony explaining why these were trade secrets and why they were valuable. And that was, if you look at Appendix 267 to Appendix 271.
267, you said?
267 to 271.
This is Mr. Noonan again.
This is Mr. Noonan. And he explains, he put a list of manuals. It's not the same list that's in the appendix at 2270, but he put a list of manuals in front of the jury, and he explained that all of the manuals taught the users how to configure, how to customize facets, how it works. And he also, having walked through the data models guide, which you can see at Confidential Appendix 31, having walked through it in detail, he explained that each of the other manuals, quote, includes about the same level of detail as the data models guide, that's Appendix 268. And he explained that each of the manuals revealed confidential, quote, architecture of facets, that's Appendix 268. And he explained that each one of the manuals revealed the configuration details for facets, that's Appendix 270. And, of course, that type of information, this court has recognized in integrated cache. The architecture of a computer program is a trade secret, and the fact that the package as a whole is not in the public domain means that it is protectable. Now, I would like to turn to the issue of damages unless there are more questions on identification. And Judge Wesley, let me come specifically to the question that you were asking about the injunction, because the Seventh Circuit has addressed the issue that you raised head on. Specifically in the 3M case. And there the court said, this is page 608 of the 3M opinion, quote, the jury's cost of development award does not render the granting of an injunction duplicative, end quote. And the reason for the Seventh...
We have to decide if we agree with that.
That's absolutely right, Judge Raji.
What was their reason?
I was going to say, and the reason for that is the same reason that the district court gave here at page 28 of her opinion, which is, number one, that the purpose of the injunction is separate. It is to prevent future harm to the trade secret owner. And this was a case, 3M...
Can I stop you just for a second?
Sure.
I want to explore this with you. So you got damages for what they made off of their use of it. And then, so you got something for their misuse of your trade secrets. Now, whether they were a good or a bad business, I mean, you shouldn't be, but you made whole for what they did for stealing, for the jury's finding that they took and used your trade secret. Then the question becomes to me, how have they been unjustly enriched? And if they can't use it, how are they unjustly enriched? By, I mean, I would think they were unjustly enriched if they competed with you because all of a sudden they're using your tools and you spent a lot of money to make them. But so now tell me, go forward then, tell me the rest of it.
Yeah, I think there are three parts to it, Judge Wesley. So the first part is the idea that avoided costs are the entirety of the value of a trade secret in the abstract, I think is a misnomer. And in fact, on page 25 of their reply, they point to university computing to suggest, that is the Fifth Circuit's decision in university computing, to suggest that, oh, well, the norm is the scourged profits. Well, the reason that's the norm is because as university computing, and this ties directly into your question, Judge Wesley, is that normally avoided costs are not sufficient. In fact, if you look at university computing, at page 538, the court said that avoided costs are frequently inadequate.
Right.
So avoided costs...
Frequently talk suggests here that you have to look at the particular case and see what damages the victim suffered. Now, if I understand it, you weren't, for the past misuse, you weren't just given their profits, you were given your losses, which were more than their profits. Did I understand that correctly?
So I don't think that's quite right, Judge
Help me
Raji.
out.
So you are right that under the DTSA, you actually, and this goes to part of why an injunction is appropriate as a forward-looking remedy. Under the DTSA, you get both. You are entitled to seek both your harm, your lost profits, and separate and apart from that, unjust enrichment. Now, in this case, just for procedural reasons, we ultimately only sought the $285 million, which is the avoided costs award. But we theoretically could have
Let's talk about unjust enrichment. I mean, if they had taken everything that they took and used it once, are you saying they would have been responsible for paying the full development costs of a rather expensive system?
Yes, and that is exactly the holding of Salisbury.
Even if they were enjoined from ever using it again, for one use, which they profited minimally on, they would have to pay the cost of developing that whole system, even though they were enjoined from ever using it again.
Yes, and respectfully,
Why would that be the law's view of what damages, compensatory damages are?
Because it's not compensatory damages. This is not the measure of harm to us. That is one form of damages under the DTSA, but we are also entitled to unjust enrichment. And as the Fifth Circuit addressed this squarely in Globe-Ranger and said, quote, you're not limited to damages based on the misappropriator's profits. And I'd refer you...
Why is the full cost of development the way in which they were unjustly enriched for one use?
Because in order to be able to use it even once, and by the way, there's a dispute that it was only used once.
Oh, no,
but,
I know that. I
yes.
was just using that
Okay, so,
hypothetical. I
sure.
understand.
I mean, they did not provide any of their financial information after 2018, which is another reason why an injunction was appropriate here. I mean, there are certainly reason to believe in that.
I haven't given anybody a hard time about that, but I'm just wondering, so tell me why then the injunction doesn't replicate or obviate the need for the recovery of the development costs.
Yeah, for two.
The cat's not out of the bag, so the industry doesn't know what you knew. Only one person did. That's not the theory. You haven't portrayed that. What else?
Right. So I agree that they had to for the circumstances of this case, that they had to use it at least once in order to be able to recover avoided costs.
Right.
But once they've used it, they have gotten the benefit of a $285 million investment. And if they actually were accountable for the losses, the development costs as losses, then they would have had a $257 million loss. They got that benefit. And that is exactly the reason of the 11th Circuit's decision in Salisbury. I'd point you to pages 740.
So it's not that they'll use it into the future, it's that they avoided having to spend it.
Yes. That is exactly right. They avoided having to spend it in order to be able to offer the competing services in the first place.
Does it also anticipate, I mean, I'm saying it aloud here because I haven't seen, there's not a lot written on this. Does it also anticipate that gives them the opportunity to try and reconstruct, not replicate the trade secret, but to figure out workarounds with regard to the similar operating systems?
Oh, there would be there's no injunction in place that would prevent them from developing the equivalent things on their own. This isn't like, there are some cases where there are injunctions that say you can't play in this space at all. That's not what this injunction is. This injunction is prohibiting them from using the trade secrets.
Okay.
That's it. And they got the benefit, they got the value of the trade secrets. If they wanted to say, they're not arguing about quantification. Maybe $285 million is a big number, but, they were acquired for $3.4 billion at this same time.
It's not like
in
they
part
took
because-
it from you. It's not like they took it from you. If they'd taken it from you and somehow destroyed its value, I can understand why you'd be entitled to get the 285, but you still got it, and the cat's not out of the bag.
Well, and you're right, if we were seeking that as harm to us, the case law says the cat does have to be out of the bag if it is harm to us. But I would encourage you to look at the Globe Ranger decision,
Okay.
the Amerisciences decision,
Okay.
Well Logic. I mean, in Amerisciences, the Fifth Circuit affirmed not only the award of avoided costs, but barring the trade secret defendant from even putting on evidence of what their actual profits were, because that would have been a distraction, and the trade secret owner was entitled to seek that. And I would really encourage you to read the Salisbury decision by the 11th Circuit. I think it is directly on point.
That's the case that you think is really directly on point.
It is, because they made exactly the same argument, and the 11th Circuit rejected that and found that, orders of magnitude more in avoided costs were the appropriate award. The last thing, if
A pre-DTSA decision.
it was a Uniform Trade Secrets Act decision, and of course, the DTSA was modeled on the Uniform Trade Secrets Act.
Thank you
And
very much.
if I may, the very last point, with respect to Judge Wesley's question about the injunction, is they obviously didn't appeal the injunction. So it's a little bit of
Right.
chutzpah to be
No,
arguing one, but when they didn't appeal the other.
No, I got that.
We'll hear from your friend on the other side. Thank you.
Thank you, Judge Lohier.
Thank you, Judge Lohier. 30 seconds on liability and then the rest on damages. On liability, I would just make 2 points. My friend, Mr. O'Quinn, doubles down on this notion that the whole documents were the trade secrets, which is what Dr. Bergeron testified to at pages 385 to 386 of the appendix. And yet there was substantial and uncontroverted evidence that there were things in the documents that were not trade
Would you
secrets.
respond to this argument that any single misappropriation of a trade secret under the DTSA would be sufficient?
Yes, there's no reason to think that the jury accepted the theory that Mr. O'Quinn propounded. And in a circumstance like this, where TriZetto was the one who sought the general verdict, it seems consistent with the general law on general verdicts that they bear the burden of an outcome where if one
Well,
or
but
more of...
you could have asked for an articulation of a specific verdict. You didn't.
Oh, we asked for a specific
Did
verdict.
you raise error here in that regard?
Well, not
You're
the-
not arguing error here, are you?
Not that as a matter of law that the court was disabled from asking for presenting a general verdict form, but we are certainly making...
You are stuck with how it was charged to the jury.
But the consequence of an error in this circumstance is that the court has to vacate, particularly where what we're talking about is the vast majority of the trade secrets at issue.
Let me make sure I understand something you just said to Judge Wesley. Did you ask for specific findings on the verdict? I did, as I said earlier, I did see where you asked for the jury to make specificity findings, but did you ask for an articulated verdict form?
My recollection is that we asked for a claim-by-claim determination. I'll check.
But not a trade secret by trade secret finding.
My belief is that that is in fact what we asked for. In other words, that each of...
If before you leave today, you could tell us where in the record that is, that would be.
Yeah, I will confirm that by letter. On the issue of damages, I want to say just a couple of things. First, I think that Mr. O'Quinn's theory here really is, as he put it, that we got the benefit of TriZetto's $285 million investment, and therefore we should be on the hook for avoided costs. Well, of course, whenever there's a misappropriation, you could say that the defendant got some benefit. Of course, our submission here is that we did not get the full benefit of that by virtue of the fact that we exploited the trade secrets allegedly only for providing services to one customer. But I think that the reason why that is such a dangerous rule is that it really makes avoided costs the floor and not the ceiling. And I would submit that if you look at the language of the DTSA, consistent with ordinary principles of remedies, that language at most makes unjust enrichment available. It does not say that you get both as a matter of law in every single case.
What is the language that you're relying on?
This is language in 1836B3B, which says that a court may award damages for any unjust enrichment caused by the misappropriation, so there is a causation requirement there, of the trade secret that is not addressed in computing damages for actual loss.
Mr. O'Quinn suggested that that signals to us that the statute does not contemplate only compensatory damages. Do you want to tell us whether you think that unjust enrichment statute, that provision deals with something other than compensatory damages?
Yeah, I would say two things about that. First, that it makes clear that avoided costs in the unjust enrichment sense could be available in a circumstance in which, for instance, the profits can't be readily calculated. I think we would acknowledge that avoided costs could be appropriate in that circumstance, but as I said to you earlier, Judge Radji, I think here it's uncontroverted that there was an alternative, much smaller figure, both of TriZetto's profits and our profits from the single, TriZetto's lost profits and our profits from the single customer.
The district court did reduce the initial jury amount, right?
Yes, but it did so by remitting the punitive damages award. And of course, the punitive damages award in turn is dependent on the compensatory award. And if we were to prevail here on avoided costs, presumably there would have to be a similar analysis on remand. But I think, again, what's so problematic about this is that it really is turning avoided costs into the floor and not the ceiling. And if you look at the cases, avoided costs are only comparatively rarely awarded in trade secrets cases. Obviously, we have even less law under the DTSA, as this court will be aware, because it was a case that Judge Loyer was involved in. The New York Court of Appeals on certification concluded that as a matter of New York law, on policy-related grounds, that avoided cost damages are not available.
I have no memory of that case whatsoever.
Well, yeah, there was at least one case cited in
Judge.
there was at least one case cited in the briefs, if it makes you feel any better, that I worked on as well, and I had only a dim recollection of that too. But I think what I would say is that there is no case, while there are scattered cases in which courts have awarded avoided costs alongside profits, there's never been a case involving an avoided costs award that is as wildly disproportionate as the award here. And at a minimum, with regard to the statutory language, Judge Radji, as we point out in our briefs, there is clearly a causation requirement. And if the way you want to think about this is sort of the narrowest possible way to think about it, I think it is to focus on the fact that because we received such a modest benefit from the alleged misappropriation, allegedly obtaining one additional customer, that you can't say that the full amount of the avoided costs was caused by the misappropriation. And so I think if the court is concerned about establishing a rule for all time in the context of the DTSA, that is a way of remitting.
Your adversary about a one-time use. Let me ask about it from your perspective. If you had a one-time use and you either didn't make very much or whatever, that would be the full scope of your liability, even though you had misappropriated an extremely valuable trade secret?
Well, it would be different if you destroyed the value of the trade secret entirely. That's our release of Coca-Cola's recipe to the world. Or I think in a circumstance in which you developed a competing product that was completely unsuccessful in the end. Now, I think that that's a closer
Say it's
case.
not hypothetical. You used it once before you got caught, and that didn't earn you very much money. But you basically took something that was very, very valuable, and instead you're only liable for, $25,000 or whatever. I mean, that doesn't seem to be what the law is talking about here when it talks about the unjust enrichment to the extent it wasn't factored into damages. I mean, that's how the law is written.
Well, I would fall back on my argument concerning causation at a minimum, but I think what I would say is that the problem with that approach, Judge Radji, is that it really means that whether you have one use, 10 uses, or 100 uses, the recovery is the same. That's what I mean when I say that avoided costs are a floor here. What Mr. O'Quinn is saying, and I think this is a very dangerous proposition of law, is that whenever you get the benefit of the investment, which is, of course, always going to be true on some level when you have a misappropriation, that full amount can be recovered. It is as if you destroyed the value of the trade secret entirely. And I would submit that even under the common law prior to the DTSA, my friends would strain to find any authority to support that broad
Well,
proposition.
Salisbury, I've got to go back to the 11th Circuit, but that's what I think he's relying on.
I think in cases in which you have a competing product, there are cases, Salisbury and Globe Ranger, where courts have upheld the award of avoided costs in some circumstances alongside gain. But this is a very different case, both because of the remarkable disproportionality of the award and because the nature of the use is fundamentally different, because we weren't trying to develop competing software. And of course, the Facet software itself was the core trade secret.
Using the software one time, that's the distinction.
Well, using the software to provide services on one occasion. And I think that is a fundamental distinction. It at a minimum goes to causation. But again, all roads lead back to the principle that in order to uphold this award, the court has to say that avoided costs are available as a matter of course, as a proxy for the benefit to the defendant. And again, I think there is a conceptual difference between, on the one hand, a circumstance in which the value of the trade secret is destroyed such that it is appropriate to look at what the plaintiff put into developing the trade secret, and a case like this, where the plaintiff's development costs are used as a proxy. And I would just underscore that I think that this is consistent with the way in which remedies ordinarily work in the trade secrets context. My friend pointed to the Fifth Circuit's decision in university computing. I would point to this court's decision in Softel, which said that avoided costs are, quote, usually appropriate only where the defendant has destroyed the value of the secret, and the cases are legion for the proposition that the ordinary remedy for misappropriation of a trade secret at common law is disgorgement of profits. And at most here, that would be not $285 million, but $8.5 million.
Thank you very much.
Thank you, Your Honors.
Reserved decision.
Thank you both. Thank you both very much.